This is Rick Frederick reviewing United States v. Bronner, a D.C. Circuit Court of Appeals case, which sort of completes the 20-year D.C. experiment. It's a great case to read if you have a couple of hours. Very long case, but filled with good information to help us understand what happened in D.C. with the application of the Durham rule, the problems that it created, and what the D.C.'s court's plan was to fix it. And the Bronner decision established the ALI Model Penal Code thoughts about insanity into their thinking, and would stay that way until the Insanity Defense Reform Act after Hinckley. So this is, an interesting case of somebody who probably doesn't have a serious mental disorder, who, as one doctor reported in his report or his testimony, he was just mad. But after a day of drinking, and also there's a question of whether he was actually drunk or not at the time. But anyway, Archie Brawner was at a party, fights broke out, his jaw was injured, he left the party, and he stated, someone's going to die tonight. He returned with the gun, fired several shots through a steel door, and Billy Ford was killed. There are a lot of different testimony including personality disorder testimony on this case. And as we all know, personality disorders may or may not be mental disorders, depending on who you talk to. And it's not clear that courts really are interested in personality traits as evidence of mental disorder. Bronner was convicted, was not given an insanity acquittal. That's the basis of his appeal. And so the issue to be decided in the Bronner case was essentially, should the D.C. Circuit Court of Appeals adopt a new rule in place of the Durham products test to govern the insanity defense? And the answer is yes. So they're going to take the ALI formulation from the Model Penal Code, which reads, a person is not responsible for criminal conduct if at the time of such conduct, as a result of a mental disease or defect, he lacks substantial capacity to appreciate the criminality, wrongfulness of his conduct, or to conform his conduct to the requirements of the law. Now, I just put wrongfulness in brackets there because this is going to be the next issue. What is wrongfulness, and is it illegal behavior? Is it immoral behavior? What constitutes wrongfulness? So this, again, a long discussion, not by Bazelon, but by another judge, that sort of goes through a variety of D.C. Circuit cases, including McDonald, which I've posted on here, the Durham rule, and then a couple other cases, Washington and Carter. Now, I've followed up this analysis paragraph in the brief with some long quotes out of Bronner to help us understand the evolution of the D.C. Circuit Court's thinking and the problems they faced. If you go back to McDonald, it's not really clear from McDonald what their problem was, but the main issue is that the doctors are understandably tempted to go beyond their own expertise to try to match their testimony to what they understand the legal components are of an insanity defense. That's what bothered the court. They wanted to accomplish that sort of temptation to the doctors with their jury instructions, to tell the jury how they should think about it, but instead the doctors found that the doctors were getting into this business of trying to match their expertise to the legal definitions of mental disease and defect. Okay, so these are the long quotes. The first example, a difficulty arose under the Durham rule in application. The rule was devised to facilitate the giving of testimony by medical experts in the context of a legal rule, with the jury called upon to reach a composite conclusion that had medical, legal, and moral components. Okay, so here's the first difficulty with the Durham rule when you say that the behavior was a product of mental disorder. It opened the door to trial by label. Well, he has a mental disorder, therefore his behavior was the product. And so, but here's an example they ran to. In regard Rosenfeld, a petitioner was described as a sociopath. So on a Friday afternoon, the psychiatrist testifies that a person was not suffering from a mental disease because the official policy of St. Elizabeth's on Friday afternoon was that sociopathic personality disorder was not a mental disease or defect. However, over the weekend, St. Elizabeth changed its policy, and as an administrative matter, that the state of a psychopathic or sociopathic personality did constitute a mental disease. So the psychiatrist comes back on Monday and says, I have to change my testimony because there was an administrative rule change at St. Elizabeth's. That bothered the court, understandably so. All right, here's another long quote. The Durham rule also required explication along other lines, notably the resolution of the ambiguity inherent in the formulation concerning actions that were the product of mental illness. Okay, so Carter v. U.S., 5 years after Durham, the simple fact that a person has a mental disease or defect is not enough to relieve him of responsibility of a crime. So you can't say, well, he has a mental disease or defect, therefore his behavior is a product of that mental disease or defect. There must be a relationship between the disease and the criminal act, and the relationship must be such as to justify a reasonable inference that the act would not have been committed if the person had not been suffering from the disease. Okay, so Carter tried to clarify Durham that to say that the mental disorder must have a necessary role. Then I think this is the final long quote regarding transitioning from Durham up to the Bronner case. The problem was identified by then Circuit Judge Berger in his concurring opinion in Blocker. The hazards in allowing experts to testify in precisely or even substantially the terms of the ultimate issue are apparent. Now, this is the first time you really see this sort of language in the case law, is whether doctors should be testifying to an ultimate issue. We know from the Insanity Defense Reform Act that they are prohibited from doing so. The only experts really in court who are ever prohibited from testifying to an ultimate issue are mental health experts. No other expert is prohibited from testifying to an ultimate issue. Engineers aren't. You know, they can go and say, well, these bolts snapped because they weren't the right diameter, and that's what caused this collapse of a structure that killed these people. But the hazard in allowing experts to testify in precisely or even substantially the terms of the ultimate issue for mental health are apparent. This is a course which, once allowed, risks the danger that lay jurors, baffled by the intricacies of expert discourse and unintelligible technical jargon, may be tempted to abdicate independent analysis on the facts on which opinions rest. And this may simply be the old problem that everybody is a psychologist, everybody is a psychiatrist, everybody seems to have an opinion about human behavior and mental disorder, but very few people, for instance, say that they are engineers, and so they look to engineers to tell them about things. Who knows? The final long quote, not relating to the development of case law, is that the Model Penal Code promulgated by the American Law Institute contains a caveat paragraph, but that is not included in the Bronner instructions. So if you look at the Model Penal Code, when it talks about insanity or criminal responsibility, it clarifies the terms mental disease or defect do not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. And this is intended to exclude defense for psychopathic personalities or antisocial personality disorder or sociopathy or psychopathy or whatever you want to call it. Our own approach is influenced by the fact that our rule already includes McDonald, which says what mental disease or defects are. We don't require this caveat paragraph because we expect that jury instructions will have already made that clarification. Okay, so that's Bronner. Again, have a couple hours, great case to read, full of clarification on what the problems are. Thank you.